Like we got 3 minutes to go and we're still waiting on Hans and Linda, I guess. Here comes Hans. There's Linda. Looks like we have everybody. We'll wait till the top of the hour, which is about 1 more minute.
Is Suvani here?
Oh, I do not see her.
We need to wait for her, and we also need to make sure the applicant and his attorney are here as well.
Okay, well, okay.
We're all here.
That's probably a good idea.
They only just sent his email address a moment ago, so. And just a quick, I know you know this, Mayor, procedural reminder, but when the public is giving testimony, we do need them to state their full name for the record and address so that we can make sure we.
Since we're taking only past testimony, I'm also going to ask them to identify, if they can, what date they testified before the Planning Commission.
Right. And I think folks just need to have been in attendance. Well, correct me if I'm wrong, but that's my understanding.
What was that again? I'm sorry.
Folks just needed to have participated, and I believe attendance counts as participation.
Yeah.
I was under the impression that this is limited only to the appellant and the Planning Commission report.
That's correct.
If you look under the specific provisions for on the record, it's the appellant provides their testimony or summarizes the project, then the Planning Commission, as a representative, I summarize their material, but there's no additional testimony.
No public input?
Not according to the code. Let me verify that.
Well,
That's
our attorney told us that we're going to ask you to go first, Walt, for 20 minutes, then the applicant for 20 minutes, and then we will give opportunity for public input if they gave testimony previously to the Planning Commission, but no new public input, no new evidence.
That's correct. And well, that's under the council rules and regulations.
Okay. I just want to let you know that the development code says one thing in terms of on the record.
Right. It's limited to what's already occurred. And we'll go through all that. Okay.
Looks like we have both sets of attorneys here, it looks like.
Yeah. Mick, is that both you and Vito? Is everyone here from your team?
He's on mute. You guys are on mute.
Can you hear us?
I can now, yeah.
man.
Okay, great. Yeah, we have Vito and Dustin and Dave Peterson. So Dustin's just manning the mute and unmute.
Okay,
Okay.
hey, all right, so that's everyone for you all?
Yeah.
Okay, great, thank you. Yep,
Yes,
we're
sir.
all here then.
Okay, well, let's get started. Afternoon, everybody. This is a quasi judicial public hearing in the matter of the appeal of Vito Sorelli, applicant of the Planning Commission's decision to deny a planned unit development application to establish a 34-unit hotel, and I'm declaring the hearing open. Let me go over a few things first, how we're going to proceed here this afternoon. First of all, I want to say that the City Council has received and reviewed all the material that was related to the proceedings that took place before the Planning Commission. And consistent with adopted City Council rules and procedures and provisions in Ordinance 95.4, Section 10.180, this appeal shall be reviewed solely on the record. No new testimony or evidence will be permitted, although parties to the Planning Commission hearings will be permitted to present arguments. So first we're going to go with, when we get started here, but not yet, is Walt, you're going to go first and make the case for the Planning Commission for 20 minutes. I'm going to ask the council to hold their questions to the end of that presentation. And then we'll give 20 minutes to the applicant to give their position, and we'll take questions from them afterwards. And then we're going to allow parties to the public to present arguments that they may have already given in front of the Planning Commission. So if you're an individual in the audience out there and you gave testimony during one of the three sessions, this was March 21st, May 16th, or June 20th, that's on the record, and you want to make that argument again, you can. But I want to reiterate that we're not taking any new evidence or any new testimony, and I can assure you that the counselors have reviewed all the tapes. We've seen all the letters in conjunction with this. So don't feel you have to have a need to repeat yourself. And if you do, you need to identify yourself, who you are, where you live, and if you can, identify which one of those 3-minute meetings I mentioned that you gave testimony at. So first of all, I got to get a couple things out of the way here. First, I need to ask the audience, are there any objections to the notice that was sent out in this case? Okay, hearing none.
Sorry. Yes, we do object to the notice. Yeah, Mayor.
Okay.
Do you want me to explain that now or later?
I don't know, Savoni, should they elaborate on that now or later? Should we just put it down on the record that they object?
That's fine, and either way.
Why don't we just note it in the record and you can discuss it during your presentation? How's that work?
Perfect. Thank you, Mayor.
Okay. Are there any objections to the authority of any member of this body or this body itself to hear and consider this case? Hearing none, I assume there are no objections. And then I need to ask the council, are there any declarations of ex parte contact, conflicts of interest, or any bias on the members of the City Council?
I have none.
None.
I have none.
Do you have any, Steve?
I have none.
Okay, and neither do I, so takes care of that. So now, before we start, I'm going to ask our city attorney, Savoni Miller, to give us a brief summary of what the council may or may not consider while reviewing this appeal of the record, and opportunities for parties to the Planning Commission proceedings to participate. So Savoni, I'll give it to you for a minute.
Thank you, Mayor Scott, and you covered it pretty well already, but just to reiterate, the council today is conducting an on-the-record appeal review. So what is before the council today is a review on the record, so considering, as the council has reviewed, the planning commission record, meaning all of the evidence, the issues, the testimony that was submitted to the planning commission in its 3 hearings. That's what makes up the record. And then the council may also consider argument from the applicant and the other parties about the record. And argument here will mean the assertions, analysis, legal argument about whether or not the planning commission's decision was correct based on the criteria and the issues that were outlined in the record. What argument will not include is new facts or new evidence. So that what the council can't consider are facts, documents, data, or other information that may be related to, or party may believe are related to the criteria that the planning commission reviewed. They can't consider that if it was not already presented to the planning commission in those hearings and is not part of the record already. So for the participants, for the parties, this means that, as you explained, anyone who participated in the planning commission level will be considered a party and may speak today, but persons who did not participate at that level should not participate. And then to the extent that any party's comments do introduce new facts or new evidence, the council will not be able to consider those in its decision-making. So parties should be encouraged to limit their comments to argument about the items that are already in the record.
Okay, thank you. I guess we're ready to proceed. So the first thing we're going to do, I'm going to ask, we're going to hear from staff regarding the Planning Commission's decision. And Leila, can I ask you to introduce Walt? And remember, the council members, let's hold our questions to the end of the presentation.
Thank you, Mayor. So I'd like to introduce Walt Wendowski. Walt is the city's contract planner and has served as the planner of review on this application since it was submitted to the city, and has been involved throughout the process. Walt will be presenting the Planning Commission's final decision on behalf of the city. So with that, I'll hand it over to you, Walt.
Okay, thank you. Good afternoon, Mayor, members of the City Council, those in attendance. Before you is an application by Vito Sorelli for property located at 698 Dorcas Lane. The subject property contains approximately 3.98 acres and is zoned special residential recreation. In this case, the applicant requested approval for a 34-unit hotel complex on the subject property that would include loft units and large and small cabins. Briefly, the project would include the following. The north end of the site would contain 19 studio hotel rooms, each designed to contain approximately 350 square feet in area. To the south of the hotel is an approximate 2,900 square foot community building for meetings or gatherings for folks who are at the hotel complex. South of this community building are 9 additional rental units. These are 1- and 2-story structures, each containing approximately 1,000 square feet of area. South of this site are 6 single-story cabins identified as micro cabins. These are A-frame cabins that share a common open space. The site plan identified 53 parking spaces and over 14,000 square feet of open space. A private roadway from Dorcas would run along the east side of the site, serving the entire development. The roadway also would include required public services. Section 3.030.2H permits hotels, motel, including an eating and drinking establishment therewith in this special residential recreation zone. The proposed hotel complex is therefore an allowed use in the zone. In addition, subsection 4C requires the Planning Commission to use the plan unit development procedures in section 4.136 when evaluating a development application. Provisions in section 4.150 regarding design review do not apply to this request, although the Commission has authority to condition their decision to include related size, position, and design of the buildings. As noted, hearings were held before the Planning Commission on March 21, May 16, June 20 of this year. At the June meeting, the commission voted to deny the application. The decision was subsequently appealed by the applicant to the City Council. Plan unit development provisions, as noted, are found in section 4.136 and are used to evaluate development proposals in the SRR zone. For the record, the project required a plan development review. The applicant submitted the required information, and the commission hearings were complied with the code provisions. Generally, the commission found the proposal met all development standards, including dimensional requirements, access frontage, building setbacks, open space, and vehicle parking. Again, these are just the basic development standards within the zone. However, there were several areas where the commission found the proposal failed to comply with the applicable criteria. This is the focus of the remainder of the report. Under section 4.136C, the commission noted the following. Item C2 states resulting development will not be inconsistent with the comprehensive plan provisions or zoning objections of the area, particularly with regard to dune stabilization, geologic hazards, and storm drainage. With regard to the findings, the Planning Commission specifically noted under comprehensive plan policy, item number 2, the plan overrides city ordinances, such as zoning, subdivision, or other ordinances when there is a conflict. In this regard, the commission found that the goals, objectives, and policies contained in the plan do apply to this development. The goal provisions in land use state the following: to guide the development of land so the land use is orderly, convenient, and suitably related to the natural environment. The uses must fulfill the needs of the residents and property owners and be adequately provided with improvements and facilities. Objective number 1 states the city will designate separate land use areas within which optimum conditions can be established for compatible uses and activities. Finally, objective number 3 notes the following: protect the character and quality of existing residential areas in neighborhoods from incompatible new development. Based on testimony and presented evidence, the commission found the proposed hotel incompatible with the area activities that are dominated by recreational uses, such as the golf course to the west, and also residential uses. This conclusion is based on the amount of traffic generated by the site and potential traffic impacts on the local street system. Further, the commission heard testimony indicating the size of the hotel is incompatible with area development. On balance, the commission found the proposal did not comply with the applicable comprehensive plan policies. Under item C3, the area around the development can be planned to be in substantial harmony with the proposed plan. There are findings. While there are single-family homes in the vicinity, the dominant land use in the area is recreational, with the existing golf course to the west. The commission found that the hotel to be incompatible with this area use. Item C5, the streets are adequate to support the anticipated traffic and the development and will not overload the streets outside the planned areas. The applicant did submit a traffic impact study, subsequently reviewed by the city's traffic engineer. Excuse me. Opponents provided a more comprehensive study. The report indicated the project would generate more than 309 vehicle trips per day. Many of these trips would be directed to downtown, where a majority of the eating establishments are located. This creates adverse impacts on streets within the vicinity. Not only is this a safety issue with the pedestrian bicycle traffic, but the commission also finds that the use and potential traffic impacts conflict with comprehensive plan land use objective number 3. Finally, under the SRR zone, section 3.030 (4) 4A talks about dwelling density within the zone. Based on the provisions here, up to 13 dwelling units per acre are permitted. With their finding, the commission noted that while submitted as a hotel project, the commission notes a number, if not all, of the units can meet the definition of a dwelling unit contained in Ordinance 95-4. Therefore, application of the density requirement is appropriate. Additional information on the specific level of improvement would be needed to determine whether the development complies with the density requirements of this section. Finally, as a general comment, the commission noted they found the various drawings and plans did not contain sufficient detail and were judged inadequate. They know this would complicate the ability of the commission to determine whether the final product conforms with the submitted proposal. In conclusion, based on these findings, the commission concluded the application to site a 34-unit hotel in the SRR zone fails to comply with all the applicable provisions of the development code. That concludes the report.
Thank you, Walt. Now we'll take questions from City Council for our planner. No one has any questions? Okay, it's very clear and concise, and I guess we don't have any questions. If that is the case, then we're going to move on and now give the applicant 20 minutes to make their response. And again, I'm going to ask the council to hold your questions until the end of their presentation. You guys are on mute again. There you go.
Yeah, Vito Sorelli, and I'm here with Dustin Schroeder and Mick Harris and Dave Peterson. Yeah, thank you for hearing this today. Just wanted to start off by saying a couple words and I'll pass it on. When we purchased the property and we did an extensive amount of pre-applications with all the city officials, the planning department, building officials, fire, water, sewer, had multiple pre-applications to discuss the rules and regulations of the SRR zone and the outright use of the development of a hotel, motel, and eating and drinking establishment. And as Walt had listed in his report and some of the subsequent staff reports, that the 19 hotel units at the top, the studio apartments as we call them, the community building that would be served and used for all people staying on premise, the 9 houses in the middle that would be a secondary type of hotel use, as well as the units on the south, would all meet the definition of the hotel, as well as the density and parking requirements of the outright zoning use. So just wanted to say that we've had a number of pre-application meetings with all jurisdictions and kind of help guide the path to this application. So thanks for hearing this today.
Mayor and council, thank you for taking time to hear this appeal today. We submitted earlier this morning a letter brief which outlines in detail the various grounds for appeal. I don't know if everyone would have had a chance to review that. I completely understand if not, but that will be in the record and provide a little bit more fleshed out version of what I'm going to go through sort of point by point in a more summary version here this afternoon. First, just to circle back as to why we objected to the notice for this hearing. On July 8th, city staff issued the notice for this hearing after we had filed our request the day prior. However, that was only an 11-day notice, and both state statute and the Manzanita ordinance itself requires at least 20 days prior to the hearing. And because there was not 20 days given, we've objected to this notice as being improperly provided and invalid for that purpose. Additionally, the July 8th notice stated that a staff report would be provided within 7 days before the hearing, and as of today, to our understanding, no staff report had been made available, which would also violate the notice in the statute. So that's the grounds for our objection to the notice. And more importantly to that, we also find that due to that improper notice, we have been substantially prejudiced in our ability to prepare for the notice, given that we only had a number of days, 2 of which were over a weekend, to prepare. And we're concerned that there was not notice provided to third parties as well. Moving on to the meat of the appeal. First, we would say that the Planning Commission erred in treating the application as one for a planned development. The application is for the development of a 34-unit hotel, which is allowed outright in the SRR zone. For reasons that are not entirely clear to us, the cover page of the Commission's order characterized the application as a planned unit development and also once as a subdivision. But again, it is in fact neither. It is an application for a hotel, which is an outright permitted use. And accordingly, because it is an outright use, it needs only meet the development standards that are outlined in ordinance 3.0304. What I think may be a point of confusion and which we want to clarify as part of this appeal is that in 3.0304C, it states that there's a procedures which are in section 4.136, which should be used to evaluate development proposals in the SRR zone. However, what's critical here is that that is, in our interpretation, a mere statement that the procedures, not the substantive criteria in 4.136, should apply. With that in mind, I will turn to, and I'll come back to that in more detail a little bit later, but I also want to bring up that one of our concerns is that the Planning Commission erred by wrongfully accepting and relying upon evidence and testimony submitted by third parties other than the applicant after the public hearing was closed. The minutes of the meetings that have led up to this point, beginning on March 21st, stated that the public hearing at which members of the audience expressed concerns and asked questions was closed to public testimony at 5:41 p.m. Due to the fact that the applicant was unable to produce requested materials by the following April 18th meeting, the record was open and the hearing was continued for the purpose of producing those materials. And it is clear to us from the Commission's minutes that the public hearing was closed to all further evidence or testimony from anyone other than the applicant as of March 21st at 5:41 p.m. And this is acknowledged in the Planning Commission's final report itself. However, it appears that after May 16th, based on notes within the Planning Commission decision, the Commission agreed to comprehensively reopen the record to allow additional evidence, argument, and testimony. This was concerning as there was no clear record of a meeting in which the Commission came to this decision. And as a result, this is in violation of the procedures provided in ORS 197.7976 with respect to the admission of public testimony. As a result of this, the only testimony in the record from parties other than the applicant that was properly admitted was 3 emails sent prior to 5:41 p.m. on March 22nd, and potentially an email and 2 other letters which were undated. Notably, the last minute testimony in the form of the letter from Greenlight Engineering, the traffic report which was relied upon by the Planning Commission in their order, is not properly part of the record. And the Commission's reliance on that letter, as well as any other improperly admitted evidence or testimony, was in error. Further, even if the reopening of the record and the acceptance of that evidence and testimony was proper, the Commission failed to give the applicant an opportunity to rebut that evidence and testimony, as is its statutory right. Again, as a result, this error substantively prejudiced the rights of the applicant to have the application considered fairly. Turning back to the distinction between 4.136 and 3.0304C, 3.0304C requires the Planning Commission to consider the application using the procedures of 4.136, but not the substantive criteria. There's a summary of those procedures which we included in the letter, but what I want to focus on is that the Planning Commission found that the first 3 steps of that procedure were properly taken, and through its order, completing the 4th step by advising the applicant. The Commission completed the 4th step by advising the applicant of its opinion on whether the 6 factors were satisfied. However, there is a 5th step in 4.136 that neither the City Commission nor city staff followed. And this requirement says that after the first 4 steps are met, the applicant must apply for approval of a planned development. The commission made a finding with respect to this 5th requirement, stating that it appeared that the purpose of the provision is to identify the site as a planned development on the city's zoning map, saying in effect that this required an approved tentative plan to be submitted, reviewed and approved. And we were struggling to understand this finding. It seems to literally conjecture as to the purpose of the code, which is not the commission's role. And additionally, it concludes that the zoning map amendment is necessary. And candidly, the reason why this doesn't make a whole lot of sense, we argue, is because this is not a planned use, a planned unit development. Instead, it's a development for a hotel. And there seems to have been some confusion potentially between using the procedure for the planned unit development rather than the substantive criteria. So then, moving to that point, there is substantive criteria in 3.0304. Those can be found in subsection B, D, and E. And in 3.030, the commission rightly found that B, D, and E were met. However, the commission erred in concluding that hotel units are dwelling units. The reason we are arguing this is that first, the ordinance itself lists motels and hotels separately from dwelling units, which we believe strongly implies that those are different and discrete uses. Second, the ordinance defines a dwelling unit as 1 or more rooms occupied, designed, or intended for occupancy as separate living quarters. And a hotel room is not living quarters, both by the dictionary definition, by the fact that hotels are uniformly recognized as commercial, not residential use, and perhaps most compellingly, because interpreting a hotel as a dwelling would have other unintended consequences, such as making hotels an allowed use in a residential zone. Thus, because a hotel is not a dwelling unit, the application of 3.0304A is inapplicable to the application. Next, we wanted to argue that most of the evidence and testimony in the record from the other parties, again, was improperly admitted, and such, any findings that were made with respect to 4.1363 are all based exclusively on improperly admitted evidence. And so those findings all fail for lack of support by substantial evidence, as there was not substantial evidence properly admitted into the record. However, if the commission's argument that the substantive criteria of 4.136 do apply to this application, the Planning Commission erred in concluding that those criteria were not met. First, the commission erred by directly applying comprehensive plan provisions to the application. Comprehensive plan policies do not constitute approval criteria in this case. The Land Use Board of Appeals has found that decision makers are not required to evaluate plan policies that are not approval criteria. And while sometimes comprehensive plan policies can be approval criteria, that must be because the decision maker evaluated the plain language of the policy and determined that it was indeed intended as an approval criteria. In this case, the Planning Commission relied on 3 statements from the comprehensive plan, none of which were labeled as policies, but which were instead labeled as goals or objectives. These were broad brush statements of aspirational goals to guide future legislation and planning, and were not approval criteria to be applied at the individual quasi-judicial land use level. And furthermore, for the commission to come to this substantive finding is illogical. The commission concluded that the hotel was incompatible with the area, despite the fact that City Council has already made the policy decision that the property is zoned SRR and a hotel is allowed use in that zone. By definition, an allowed use in the zone cannot be incompatible with the zone. The commission's decision effectively overruled the City Council's own zoning decisions, and for that reason cannot stand. Finally, the commission erred by concluding that the area around, by concluding that 4.1363C is not met, because this ordinance on its face required a finding that the area around the development could be planned in substantial harmony with the proposed project, not the other way around. The commission rewrote the criteria to state the opposite of what it said. And furthermore, if the criteria requires the project to be in substantial harmony with the surrounding area, the project is by definition a proposal that meets this requirement because, again, it is an allowed use in the zone that meets all applicable approval criteria. And also the commission erred by concluding that surrounding streets are inadequate to support the traffic anticipated from the project. First, again, I want to emphasize that there was no evidence properly in the record by which the commission could find that that criteria was not met. So the finding fails for lack of substantial evidence. And the commission's finding is unreasonable on its face The only traffic impact that the commission found unacceptable was the daily number of additional trips on the peak day, which is Saturday. However, this is only on the peak day. On other days, the added trips were substantially lower. And during the busiest hour on Saturday, the report concluded that the project would generate 20 trips, or only one trip every 3 minutes. We argue that it would be flatly unreasonable to conclude that a project that will produce at most only one additional vehicle trip every 3 minutes, and only during the busiest single hour of an entire week, generates unacceptable traffic impacts. Moreover, the city's own engineer agreed with the scope of the analysis initially, and we believe that this is important for the record, and the commission speculated that most of the trips would be directed to downtown without, again, any evidence to support that contention, nor any explanation of why that made a difference. Again, the commission erred by relying on a broad brush statement from the comprehensive plan as if it was an approval criteria to be applied in this case. Finally, we feel that the planning commission erred in finding that the applicant's materials that were submitted in support of the application were inadequate and did not provide sufficient detail for the commission to determine if the approval criteria were met. Despite the commission finding that in reviewing the drawings and plans, they did not contain sufficient detail, we believe that first, this was an error, as it was predicated on the erroneous conclusion that the applicant proposed a plan development. And furthermore, we did not find this reasonable. We asked that the city council independently review those plans and drawings and conclude for itself whether they're adequate to allow meaningful review of the proposal. Specifically, we direct the council's attention to the site plans and the artistic renderings, as well as the 3D exterior views and composite elevations. Given the quality and detail in those renderings, we are at a loss as to what could be missing from those materials, and the planning commission's order did not specify. For these reasons, we believe the decision of the planning commission should be reversed and the application approved. Thank you for your consideration.
Thank you.
And I'm happy to take questions. I can
Sure.
spend the rest of my time.
Yeah, you have any questions from the council for the applicant?
Mayor, I've got an initial question. Mr. Harris, I believe in the record of the June 20th hearing before the Planning Commission, you submitted a letter accepting the findings or the approach taken by the city's contract planner at that point. And I read that to mean that you agreed with his analysis using the land unit development section of the code. Did I read that incorrectly?
My name is David Peterson. I'm an attorney here at Tompkins Park as well. I'll field that question, seeing as I was the author of that letter.
Sure.
At first, I think it's worth noting that the staff report we were responding to recommended approval of the project. So we're here in a much different posture than we were at the time we were before the Planning Commission. But we were focusing specifically only on one piece of Mr. Wendowski's analysis, which was the question of whether comp plan policies constituted approval criteria. We certainly didn't intend to comment on any other parts of the application in that letter, one way or the other.
At what point during the 3-meeting Planning Commission process did you alert the Planning Commission or city staff that you objected to the PUD analysis?
Well, if you mean, when did we object to the application of specific plan development substantive criteria? We did it immediately after the Planning Commission actually did it, which was in their order. The procedural requirements required a discussion of those criteria. I think part of the problem here is quite frankly, you've got an inconsistency in your code that directs the Planning Commission to use the procedures for a PUD in evaluating a non-PUD application, and then embedded within those procedures in the way your code is written are the substantive criteria. So they have to kind of flesh out the procedures from the criteria. And one of the procedures is to advise the applicant about whether they think these particular criteria are met. I would note, though, that the very next step then requires an application for a planned unit development, which is, of course, an after the fact step, which has neither happened nor has the applicant been requested to file one. So to answer your question, we objected when the commission applied them, which was following its June 20th order.
Can, Mr. Mayor, can I ask Walt to weigh in on that, just so I have a clarity on when?
Sure.
All right.
I do recall that the letter was submitted prior to the June 20th meeting. And if I recall, Scott may help me out on this one, but if I recall, I think that was part of the packet of information.
Well, Walt, I was hoping to hear more about your take on utilization of the planning unit development part of the code.
Well, I don't necessarily, let me see. It appeared to me that the use of a PUD was required to process the application. And the PUD process includes a series of decision criteria. And so we have worked on at least 2 or 3 cases prior to this one that were in the SRR zone, where we did incorporate the PUD process.
And to be clear, are you disagreeing with the position taken by the proponent's attorney or the applicant's attorney that use of the PUD regs is proper procedurally, but not proper substantively?
No, I would think that you have to take the whole package. I don't see anything there that says disregard the decision criteria. It says you will process this as a PUD. Let me use another example. If you process it as a conditional use, you process the public hearing also with the criteria. And I think the two are linked.
Okay. And throughout the elongated process in which you supported the planning commission's decision-making over 3 meetings, had you previously heard this argument about the PUD not being substantively appropriate?
No. In fact, I first ran into the use of the PUD when I ran through my first case in the SRR zone. And it was pretty clear at that juncture, it said you have to go through the process. And again, just like a conditional use or whatever else, if there's a process involved, you also take the decision criteria that go with it.
Okay, thank you.
Respectfully, Councilor, this is not a conditional use; it's a permitted use, and that's the primary difference. And what the city may have done in previous applications is also not relevant, because the applicants may not. I mean, for all I know, their projects were approved, so they may not have been motivated to oppose. I mean, just because it was done previously, if it was done incorrectly, that doesn't make it proper to do it incorrectly this time. So, thank you.
Have any other questions for the applicant?
Mayor, I'd have a couple of questions. And good afternoon to the 3 gentlemen, and any one of you can respond to these questions. I heard during your presentation that you take exception to the green light engineering traffic analysis, but what I heard was the exception was based upon the timing of the submittal. Do you have any comment regarding the content of the report?
Well, yes, I mean, without stepping away from our objection that it's improperly admitted, at prior to the admission of that report, you had a report from the applicant's traffic engineer, you had a concurrence with that report from the city's own engineer that it adequately analyzed the impacts of a project of this nature. The opponent's engineer basically decided that, stated their own opinion that a different scope of analysis should have been used. So it's a disagreement over the scope. That report really only objected to basically which intersections were studied. They suggested that 2 other intersections further away from the site would have been studied, but that was not, certainly that was not scoped by the city at any time prior to that. I do believe, if I remember correctly, most of the remainder of the report was mainly just objections to the methodology and possibly also suggesting that the applicant's traffic engineer hadn't visited the site because they made a mistake as to how many stop signs there were. You know, if anything, the error by the applicant's traffic consultant was disadvantageous to the applicant because they assumed a 2-way stop when in fact there was a 4-way stop, which would just be better traffic control. So, you know, it's a last minute report that just conjectures that the staff and the applicant failed to properly agree on a scope of a traffic study. I would say at the very absolute minimum, the applicant should have been given an opportunity to respond to that, considering I believe it was submitted at the hearing. Isn't that right, Vito?
Couple minutes before.
Yeah.
Okay. One other question I have for you, talking about the comprehensive plan. Within the definitions of the SRR zone in the comprehensive plan, there is a suggestion in that document that commercial enterprises are subject to support of a development. Are you aware of that section?
Not specifically.
So do you have a comment? I guess maybe take a moment and look at the definition of an SR zone in the comprehensive plan. And I would appreciate a comment if you have one regarding that.
Well, I don't have your comprehensive plan in front of me, so I'm regrettably not going to be able to do that at this hearing. Maybe you could tell me what it says and I can comment on it.
Well, yeah, I'm reluctant to do that. I'd rather have you, I guess, read that. And if you don't have access, I mean, it's accessible on the internet.
Yeah, so then maybe we'll save our response to our rebuttal then.
All right.
Any other questions for the applicant at this time?
Are there other people waiting to testify? I mean, I don't know if there's anybody to rebut. We only see 11 windows on our screen, and I don't see any members of the
Well, what we're going to do next, if there's no more questions for you guys, we're going to allow people that gave testimony before to speak, and you'll have a chance to rebut after that.
Okay, thank you.
They have to say. Are there any other questions right now for the applicant? Okay, not hearing any. So what we're going to do now is we're going to open the floor to the parties who participated during the Planning Commission hearing who wish to present an argument, not new evidence or no new testimony. But if you testified before, you can make your comments again. I want to explain that you understand that the City Council has reviewed everybody's comments. We've listened to the tapes, we've seen the letters and everything that was sent to the Planning Commission. So it's not like we're not aware of what transpired, but if you'd like to state your case again, you can. For up to 5 minutes, I'd like you to identify yourself, where you live, who you represent, and if you can, tell us at which one of the 3 meetings you made your testimony. And that would have been March 21st, May 16th, or June 20th, and you have 5 minutes. So do we have any hands raised? Anybody wants to, that meets that criteria and wants to talk?
Looks like we have Rick.
Okay, Rick, go ahead and identify yourself.
Hello, my name is Rick Nyes and I'm Principal Traffic Engineer with Greenlight Engineering. The address is 13554 Rogers Road, Lake Oswego, Oregon, 97035. And I've been asked by concerned citizens of Manzanita to review the transportation impacts. I wanted to start by just addressing some of the comments of the applicant's attorney regarding the scope. My opinion is really there was no analysis of any intersections at all. The applicant's traffic engineer noted that they noted that the intersection at Dorcas and Classic operates adequately at level service A. and that even the peak traffic volumes were fairly low. But if I'm there observing an intersection, I would definitely pick up on whether or not the intersection is two-way stop controlled or all-way stop controlled. So to me, that makes me question whether or not the applicant's traffic engineer was there during peak times or at all. Kind of jumping back into my typical testimony. In order to approve this application, the city must find that the streets are adequate to support the anticipated traffic, and the development will not overload the streets outside the planned area. So the applicant thus far has relied upon opinion and not data, and certainly not substantial evidence in attempting to establish compliance with this requirement. The city planner suggested to the planning commission that off-site improvements couldn't be required of the developer. However, the city's job is to establish that the streets are adequate per code, and if they aren't adequate, then the city must either, one, require that the improvements necessary are made to the streets to make them adequate, or the city must deny the application. The city's downtown transportation plan evaluated the US 101 Lanita Avenue and 101 Manzanita Avenue intersections and found that by 2022, those intersections would easily fail ODOT mobility standards and result in unacceptable congestion. You'll note that ODOT did make some improvements at those intersections several years ago, but largely those intersections didn't actually add intersection capacity. The proposed development is expected to generate up to 309 vehicles per day, and a number of those trips will travel through those intersections. Yet neither of those intersections were analyzed in the applicant's traffic analysis. The downtown transportation plan also adopted a special roadway cross-section for Classic Street that included a 40-foot right-of-way, a 20-foot wide roadway, a 10-foot wide shared bike ped path behind a 6-foot wide landscape buffer. And the existing Classic Street frontage along the development falls well short of that standard cross-section. The road's roughly 21 to 22 feet wide with none of those other facilities. So when the development generates a substantial traffic such as this one, this would be the perfect opportunity to require those improvements. And those improvements are certainly not considered to be off-site as they're on the project's development frontage. Next one, providing their opinion about the Classic Street Dorcas Lane intersection, the applicant's traffic engineer noted, and I quote, "Volumes are typically low on these streets, even during peak season. And I quote, while a detailed analysis has not been prepared for this review, it is expected the intersection operates at a level service A with very low delays with the two-way stop control." Again, that's just getting back to the fact that it's unclear that the traffic engineer even visited the site because this is such an obvious situation that should have been observed if they were actually at the intersection. So there's certainly no substantial evidence in the record that these intersections actually operate adequately. There's really no data, just opinion, and it's perhaps based on a site visit that didn't occur. Next, the applicant's traffic engineer suggests that 280 feet of site distance should be required at the proposed site driveway to Dorcas Lane. The site driveway is proposed along the western property line. In order to achieve adequate site distance, vegetation removal may be required from private property, possibly necessitating a sign-line easement to ensure that adequate site distance can be achieved and maintained. The application provides no evidence that this can actually be achieved. Additionally, the site driveway, which carries the equivalent of 30 single-family homes, would be approximately 50 feet west of the Classic Street Dorcas Lane intersection, which is, in my opinion, very close. This proximity could cause issues for both intersections, which haven't been studied or evaluated in any way. So in closing, the applicant's traffic engineer collected no traffic counts, performed no intersection analysis, and may not have even been on site to review the project in person. Based on that information and lack of any other substantial evidence, I'd argue the city cannot determine that the streets are adequate to support anticipated traffic, and the development will not, and the development won't overload streets outside the planned area. Thanks for your time and attention. I'm available for any questions you have.
Thank you, Rick. Do you have any questions for this individual? We'll let the applicant can rebut at the end of the session here. Do we have anyone else who wants to give testimony that gave testimony during the planning commission hearings?
Next, we have Brian.
Okay, Brian, you have 5 minutes. Please identify yourself.
Hi, can you hear me adequately?
You certainly.
My name is Brian Postal. I'm a full-time resident of Manzanita. I reside at 381 Jackson Way. My signature can be found June 9th, 2022, in a document with several signatures that were submitted. And I appreciate the opportunity to be a fully engaged citizen. I'm impressed by how clear, straightforward, and unequivocal the Manzanita Comprehensive Plan is in the presentation of its intention and goals. This is a foundational document. The Comprehensive Plan should not be viewed as merely aspirational. I'd like to read several short quotes from the document, starting with this. The Comprehensive Plan is the most important land use document of the City of Manzanita. Its purpose is to establish goals, objectives, and policies for the future of the community. The Comprehensive Plan has the force of law. It is intended to guide development in a way that is keeping with the desires of the majority of the citizens and property owners in the city and urban growth area. The plan overrides other city ordinances such as zoning, subdivision, or other ordinances when there is a conflict. The plan is the means by which the conflicts are resolved. Its interpretation by decision makers, city staff, or the courts should resolve differences of opinion in the use of land. The plan is intended to protect the natural environment while encouraging high-quality development in an orderly manner. The plan is not to be used for the benefit of a few property owners or special interests, but for the city as a whole. Land use determines the kind of city Manzanita is and will be, and is a matter of civic concern. A purpose of this plan is to influence future development by establishing land uses which are harmonious with each other and with the natural environment, as well as compatible with existing uses. And finally, a last quote, the plan is not static. This document is the update of the original plan, which was prepared in 1975 and revised in 1986, 1987, 1990, and finally 1995, and must be kept up to date to deal with current conditions. In summary, I encourage the City Council to uphold the Planning Commission's carefully considered decision to deny the planned unit development application as submitted. Going forward, I also encourage the City Council to pause the approval of any major development until a much-needed review and update of the comprehensive plan can be completed. Thank you for your consideration.
Thank you, Brian. Do we have anyone else who would like to testify?
Next, we have Sandy.
Okay, Sandy, you have 5 minutes. Please identify yourself.
Can you hear me?
Yes, we can.
Okay, my name is Sandy Wood. I live at 120 Beeswax, and I have written many letters and testified both City Council and Planning Commission. Thank you for allowing public testimony. I know this is a very heated discussion. The Planning Commission, in its findings, determined at least some of the proposed units should be considered dwellings and also stated that it would impact density requirements. These issues are outlined in Section 3.030 Special Residential Recreational Zone in the Manzanita City Code. At least 9 of the units, maybe more, meet the definition of dwelling in Manzanita Code. I find it particularly curious that the applicant himself is using dwellings on his site plan for the 9 units to count parking places. Additionally, in his initial site plan submitted for the March 21st, 2022 Planning Commission meeting, there were dashed lines to signify possible partitions of these 9 units as homes. The staff report for the March meeting states, quote, phase 2 includes the 1,000 square foot cottages. The submitted plan includes possible property lines, dashed lines, for a possible future partitioning of the property. What exactly is the intent here? A partitioning of 9 dwellings, not hotel rooms in the future? If these buildings are to be partitioned in the future to be dwellings, aren't they dwellings now? If these units are dwellings, then the density standards of 6.5 dwelling units per acre also apply. The applicant did not address these issues in his application at all. I too request that you uphold the Planning Commission's courageous denial of the project based on the fact it did not deal with the dwellings or density standards in section 3.030 that must be applied to the project. And I agree with everything that Brian said. Thank you.
Thank you, Sandy. Do we have anyone else who would like to testify?
We do. Next, we have Denise.
Okay, Denise, you have 5 minutes. Please introduce yourself.
Thank you. My name is Denise Loffman. I have a family home at 663 Dorcas. I attended and spoke at both the March 21st and June 20th meetings and submitted several letters as well. The Manzanita Planning Commission made the right decision to deny this project. The PUD standards apply, and they provide a solid legal rationale for both the Planning Commission's decision and its findings. Overall, Manzanita City Code requires multiple issues be addressed at the time of application. However, the staff report wrongly tried to push much of the decision-making to the staff level. This is incorrect, and all issues listed in the code must be addressed now during the decision-maker's review process. The staff report seeks to eliminate the council's understanding of its discretionary power, framing the decision as a vague, overarching action with no discretion for decision makers. It's specifically written to picture the decision council has to make as non-discretionary, and this portrait is inaccurate. It's biased towards approval, and it is directly contrary to Manzanita's ordinance's requirements that apply to this application. The requirements and the criteria in the code have not been met. The application is incomplete, and the record illustrating these facts is more than adequate. You have received and reviewed numerous letters detailing issues neighbors have with the project that are related to comp plan and zoning ordinance provisions. And I'll just give a few examples. The dwelling and density standards in section 3.030 for the SRR zone have not been met. The requirement for a conditional use permit for a community building have not been met. The issues with traffic have not been fully addressed. Utilities and infrastructure have not yet been addressed. Wetland issues continue to linger. The required geologic hazard report for a beaches and dune overlay zone, which this property does lie within, is not yet completed. So I believe it's a good thing that the city has the PUD requirements in section 4.136 that tell us how to evaluate this proposed 34-unit hotel, which is the largest that would be built in Manzanita in 40 years, and it's going to be placed in the middle of residential neighborhoods. The city has little in its code actually to provide guidance on how a hotel or motel is defined, let alone sited or operated. The Planning Commission recognized that the applicant did not provide enough information and did not meet the burden of proof for this project, and then correctly, courageously, and unanimously denied the project. Like the Planning Commission, the City Council does not have all the information required by code to make a reasoned, fully informed decision, and must also deny the appeal. Thank you very much for your time.
Thank you, Denise. Do you have anyone else who would like to testify?
We do. Mary.
Hi, Mary. You have 5 minutes. Please identify yourself.
Hello, my name is Mary Reeve. I live at 355 Jackson Way. I'm a full-time resident of Manzanita. I live actually directly across from the property. I'm right above it. I feel that there are safety and liability issues that should be addressed before approval of this project. Even though safety was raised at multiple planning commission meetings, Mr. Sorelli did not address them. He did mention that houses are built on golf courses everywhere. However, those houses are planned dwellings when a golf course is built. Those dwellings are placed so that there is little chance of being bombarded with flying golf balls. And anyone who is near this course or who has golfed on it knows that the wooded area along hole 5 is a great place to find errant golf balls. It is not unusual for me to find a golf ball in my yard. The balls make it that far. The city needs to take a hard look at what the safety issues will be at this site. It is not out of the realm of possibility that at some point someone will be in the way of one of those balls. And at some point, the city could be deemed responsible for that. Thank you for the opportunity to speak.
Thank you, Mary.
Okay, next we have Matthew.
Okay, Matthew, you have 5 minutes and please identify yourself.
Hi, I'm Matthew Goodrich and I'm a resident. I live at 368 4th Place. I spoke at the June 20th meeting. And I would like to speak to you about the Manzanita Comprehensive Plan. I would urge the council to follow the MCP, Manzanita Comprehensive Plan, as the lens in which it views all city ordinances and zoning laws, as it is directed to do on page 1, item 2 of the MCP. I quote, "The plan overrides other city ordinances such as zoning, subdivision, or other ordinances when there is a conflict." The MCP is the heart and soul of our city, not unlike the Constitution is the basis of our country's laws and must be adhered to. The MCP states, "The plan is the means by which conflicts are resolved, and its interpretation by decision makers or the courts should resolve differences of opinion in land use." The MCP states, "Protect the character and quality of existing residential areas and neighborhoods from incompatible new developments." I am not anti-hotel, but the area the developer is asking to build a hotel is not compatible with the neighborhood and does not have a majority of support from our community and does not serve the SSR development as is required by the MCP. I urge the council to deny the application. Thank you for your time.
Thank you, Matthew. You have anyone else?
Yeah, next we have Ben.
Okay, Ben, you have 5 minutes. Please identify yourself.
Well, I'm not Ben.
Okay, well, tell us who you are then.
I'm Kim Rosenberg, and I live at 280 Edmund Lane in Manzanita. And I have been to, I think, the May 16 and the June 20th meetings, and I've written tons of letters. So I'd like to say that the words that we use matter. In our ordinances and our comp plan policies, words like require, prohibit, must, shall, set limits and allowances for the way that we use the land. Those words are like the I-beams that hold a house together. Throughout this application process, people have brought up the same concerns: the inadequacy of Classic Street to carry so much traffic, safety issues on a heavily traveled road with pedestrians and bikes, the inadequate stormwater system, the problematic wetland. These concerns have been brought to the council's attention previously. And in the past, staff and council agreed that the road and stormwater system were inadequate and that there's a wetland on the south end of the property. Nothing has been done to improve the road or the stormwater system, and the wetland has yet to be delineated fully. Yet the current staff report, traffic analysis by the developer and the city's engineers now say that the roads are adequate and safe, that the stormwater system is adequate, and that there is no wetland. The only thing that changed about the property is ownership. When the words we read in these land use documents can be interpreted to mean something we know isn't correct, we lose our faith in the processes and systems of government. When the reality we see and experience around us is denied by the people who hold positions of authority, it erodes our trust and it divides the community. While we know that the comprehensive plan's goals are aspirational, its policies, when they're written in mandatory language, do hold the force of law. Council has used the plan on more than one occasion to deny an application that wasn't right for some reason. Applicants can always reapply. I applaud the Planning Commission in their brave and unanimous decision to deny this application, and I hope the council will uphold it by the same unanimous decision. Thank you for your time.
Thank you, Kim.
Okay, last we have is Brad.
Brad, you have 5 minutes. Please identify yourself.
Yes, my name is Brad Merrily. I live at 786 Cherry Street in Manzanita. I gave public testimony on the June 20th meeting. I would like to thank the council for hearing my comments. The Manzanita Loft PUD application is incomplete and should be denied as recommended by the City Planning Commission. As stated in the application, the proposed project includes a community building. According to code in the SS and SRR zone, a community building requires a conditional use permit, which has not been addressed by the applicant or the city staff. The June 10th, 2020 staff report states, quote, a second component is an approximately 2,936 square foot community building for meetings or gatherings. Of this, approximately 1,300 square feet will be undercover and include a kitchen and identified bar area. The outdoor patio includes a fire pit. The building in question is attached as the quote community building. Under section 3.030 Special Residential Recreational Zone SRR, Part 3, it states that, quote, in an SRR zone, the following conditional uses and their accessory uses are permitted to the provisions of Article 5, letter D, community building. Article 5 states that a community center may be authorized as a conditional use after consideration of the following factors: sufficient area provided for the building, required yards, off-street parking, site location relative to the service growth needs, site location relative to land uses in the vicinity, and adequate services from principal streets, together with the probable effect on traffic volumes of abutting and nearby streets. The conditional use has been completely ignored in both this application and staff report, effectively making this application incomplete. This was discussed in minute number 278 of the July 18th, I believe 20th, 2002 Planning Commission meeting when Commissioner Phil Mannion raised concerns about the incomplete community building plan, and commissioners found that the current PUD plans do not have enough detail and are incomplete. I bring this up as just one more example where the applicant has not met the burden of proof for the project and hindered the ability for the city to comprehensively follow its own code. The requirements are being disregarded and dismissed. Please enforce Manzanita's code criteria and uphold the Planning Commission's decision to deny this permit. Thank you.
Thank you, Brad. Do we have anyone else, Nina, would like to testify?
We do. Next, we have Deborah.
Okay, Deborah, you have 5 minutes. Please identify yourself.
Hello, Deborah Simmons. I live at 256 Treasure Cove Lane, full-time resident of Manzanita. I just wanted to agree with Mary's comments about livability. I was impressed with the thorough and careful job the Planning Commission did in their research. And one of the common concerns was significant safety issues. I would like to urge the council to deny the permit just as the Planning Commission did. Thank you for your time.
Thank you, Deborah.
Okay, next we have Donna.
Hey, Donna, you have 5 minutes. Please identify yourself.
My name is Donna Miller. I live at 869 Knobcone Street in Manzanita. Council members, before you deliberate on the development of 8968 Dorcas Avenue, here are some facts about traffic that I don't think have been considered. We have heard testimony from both sides about the impact or not from the increase in traffic that this hotel will bring. We've heard about the safety and liability for future guests, rightly real concerns. However, no one has talked about the impact 5 years of construction traffic has on a residential neighborhood.
Mr. Mayor, we'd like to object to this testimony on the grounds that this is new evidence. This hearing is on the record.
Okay. It sounds like new evidence and we have an objection. So Donna, I'm going to stop you from.
Okay, I understand, but traffic is traffic, so.
Okay, well, we're trying to stay on the record with this testimony, so.
Yeah, I
Thank you.
get it. Thank you.
Okay.
I'll
Thank you.
publish it.
And that's all the hands I have.
Okay, well, what we're going to do at this point, if there's no one else that would like to testify, is we're going to give the applicant a chance to rebut any of this testimony that we just heard. So,
Mayor,
yes.
2 more hands just popped up. Do you want to take those or do you want to move
Yeah,
forward?
okay, we'll give them, go ahead.
Okay, Brian is the next one.
Brian, you have 5 minutes. Please identify yourself.
Thank you. I'd just like to quickly echo all of the comments that have been made, and specifically those of Denise Loffman. First of all, I live at 598 Dorcas Lane. I'm only 1 block away from the proposed development. I believe that all of the concerns that have been raised with regard to traffic, safety, et cetera, should be taken serious consideration by the council, and the arguments raised by Denise Loffman, I'd like to support wholeheartedly. That's it. Thank you.
Thank you. Do you have one more, Nina?
We do. Oh, sorry, the hand just went down.
Okay. Well, now we're going to give the applicant a chance to rebut any of this testimony that we received from a dozen or so individuals. So if you guys want to take a minute to respond, you can. You don't have to, but you can.
We will, Mayor and Council. Thank you very much. First, I want to respond to statements made with respect to the traffic report, particularly the last minute traffic report, which was submitted in the June meeting. I want to emphasize that that report was inadmissible because the record was closed and thus has to be treated as unpersuasive. And if the City Council determines to treat it as anything other than inadmissible and unpersuasive, then it is going to be substantially prejudicing us. We only found out on the 15th that this was going to be a hearing on the record. We've had very limited time to respond, to prepare. And so I just want to speak to that. And I also want to point out again that what is admissible and should be treated as persuasive was the fact that the city's engineer agreed with the applicant's third-party traffic report as to the fact that it would not be problematic in opposition to the requirements laid out in the ordinance. Second, I just want to point out that the comprehensive plan guides the zoning code, and the zoning code provides the criteria for the approval. And it's very important to focus on the fact that in the ordinance, a hotel is an outright use that is allowed and permitted in the special residential and recreational zone. And to Councilor Nuttall's point earlier, he referenced what is the comprehensive plan's own definition of this zone. It says explicitly that uses in this zone may include single family or multifamily dwellings and commercial uses. So there's no question that based on the ordinance which was created to effectuate the comp plan, that this is an outright use. And also, we strongly argue against any perception that these are dwelling units. They are not dwelling units. However, if the city council were to treat them as such, it would be important to recognize that ORS 197-307, the needed housing statute, as it's colloquially referred to, would apply and would require both that any land use criteria applied to a housing project is clear and objective. And as a result, no discretionary criteria would be applied. And second, that if the council had to choose between denying or approving with a condition, the statute requires the council to approve with a condition, which perhaps there would be a condition which would alleviate concerns about traffic. But it's important, again, we do not see this as dwelling units, but if they were dwelling units, ORS 197-307 would apply. The applicant has spent significant time and energy trying to make sure that they are abiding with the code as it has been set by the council, and we just want to make sure that that's top of mind. Do you want to say anything, Vito?
I mean, I would just like to follow up on a couple of items, like, again, talking about the traffic study, the zoning, had a number of meetings with Walt and Scott and the city manager, and went through, comp plans, zoning ordinances that have, established and driven by the comp plan and have outlined areas within the city of Manzanita where these uses should apply, and thus
I think we lost Vito. At least I did.
I lost their audio also.
I think we lost your audio there, Vito, at the end. You're on mute right now. Try to unmute yourself. There you go. Try it now. No, it still says mute.
It's unmuted now.
Try to talk, see if we can hear you. We can't hear you.
can you hear me now?
Yes.
Want to
Talk fast.
Okay, sorry. What I was saying is I just wanted to note that I went through a lot of effort to meet with the city planner, with Walt, with Scott, the manager, and again, I was noting that, through all these applications and meetings, we went through the comp plan, we went through the zoning ordinance, and which has been driven and guided by the comp plan and has established areas in the city of Manzanita for this outright use. I feel like this application, as we've noted to date, has covered all the grounds and requirements that are within the code. There's been some areas that have been asked upon us to bring to attention traffic analysis that hasn't really been a part of a city code to date on multiple projects. They didn't have a process in place, which is why we hired a third-party engineer, as well as the city reviewed that and had it vetted and also concurred with its application. Some of the other items that have been brought up with the parking on the site, the density, have all been reviewed and met. And for the last 3 months plus of hearings, the staff report has given outright use and outright approval of this application. So I appreciate everyone's time and energy reviewing this, but I feel like a lot of energy and effort has been put into this to make it a beautiful project for the city of Manzanita that's integrated into the landscape and covers and is, within the code and the boundaries set by the zoning ordinance, who have at one point the city council have put into place based on the comp plan. So thank you for your time.
Thank you. So,
Mayor, may I just follow up as well? And I just want to make sure the record is accurate. Mr. Harris made a comment about the question I'd asked earlier on the SRR zone definition. And when he read it, he stopped prior to the end of that particular sentence, and I just want to make sure that my question actually had to do with the portion that was left out. And I'm going to read the sentence just so we're clear. They indicated they're going to stand on the record, so they may or may not want to respond to this, but uses may include single family or multifamily dwellings and commercial uses, which is where you stopped. But it goes on to say developed to serve the development. And my question earlier in the meeting was simply essentially how you look at that in terms of what development this project, for example, might be serving.
Does the applicant wish to respond to that? You're on mute again.
Okay. Okay, so you're gonna get feedback here. I'm gonna have to go out in the hall. Sorry, our microphone is broken on our Zoom connection. So, the remainder of the sentence about intended to serve the development. Yeah, I think that just basically means intended to serve the neighborhood in which it's located. I'm not really sure what else to interpret that by, but I'm going to circle back to Mick's original point, which is that, this is not about applying the comp plan directly to this application, right? Your zoning code exists to implement the comp plan, and the zoning code sets forth the regulations. Somewhere along the way, the city council made a decision that hotels are a permitted use in this zone. And that decision was made with the comp plan fully in front of them, fully at top of mind, because that's what you do when you write a zoning code, is you write a code to implement your comp plan. So that's what's going on here. And this idea that we can use the comp plan to somehow do an ad hoc rezoning after the fact and say, well, maybe not all hotels are permitted uses in this zone is really it's not appropriate. I mean, that's a policy decision that the council may want to take up at some point in the future, but it's not relevant to this pending land use application, where the applicant has the right to proceed under the code that was that applied at the time his application was complete. So I'm struggling a little to understand maybe where we're going with this line of questioning about the comp plan language. I mean, maybe it can be read positively, maybe it can be read negatively. I'm not entirely sure, but the point of the matter is the zoning code is what we're supposed to be applying to this application.
Okay, thank you.
Mayor, I want to pick up on a couple of things that were just said. The reason why we're talking about the comprehensive plan is because the decision-making body below us that presented us with this decision put it front and center right under our noses, and we have no choice but to figure out how it applies, if it applies, and what it means if we do apply it. So that's why we're talking about the comprehensive plan. But when we do look at the section of the comprehensive plan that Councilor Nuttall directed you to and that you read from, it seems to me that the term development as used in that sentence must refer to the way it was used 2 or 3 sentences above that in the same section, where it talks about the character and density of the residential development has yet to be established in the SSR zone. Because that was written 2 years ago. Now we have more development. We've got the cottages right across the street. We got the Highlands popping up below those. We've got more development on Dorcas. So we have a better idea of what the development and the character of the residential neighborhood in the vicinity looks like. And so it may be that we've got a comprehensive plan that hasn't been properly updated or hasn't been properly reviewed to ensure coherence with the zoning code. And so that, with all due respect to the applicant, we're struggling as a council to figure out, how we should rectify a situation where the folks that know planning and zoning best in our community, the Planning Commission, has exhaustively considered this and has come back and has told us that the comprehensive plan is at play And we're seriously considering that right now. And I think that, there are many reasons why a lot of folks in the community would like to see a development like this, not located in this location perhaps, but like this. There's plenty of support for the notion of more entities like Coast Cabins, for example, that could produce significant transient tax revenue and perhaps replace short-term rentals to some extent. So it's not an objection to the concept. I think the clear concern is the particular location, and there doesn't seem to be any indication that this project would serve the residential development in that area that has popped up, I should say, since the comp plan was last updated. And you certainly don't serve it doesn't appear you serve the golf course. The golf course has made it clear that they oppose the project. So perhaps you can help us out, or help the community out, or explain to us. I don't believe that we're using, or the Planning Commission is using the comp plan as approval criteria. I think they're suggesting that the approval criteria is not in concert with the overriding and overarching intent of the comp plan when it established the SRR zone. That zone was created for a particular purpose that has never come to pass. And I think we have a different situation in that part of town now than we had 22 years ago. So we are looking for help and insight and guidance, and continue to offer it. But that's why we're talking about it. I don't think we're not trying to waste anybody's time talking about it. It's a very critical concern, clearly, to the community. So that's why we're talking about it today.
That question is directed to us or to staff? I wasn't sure.
What was that?
Is that a question directed to the applicant or to staff? Or
That's to the applicant. If you guys want to respond to that, we'll let you respond to that, and then we're going to move on to deliberations. But
I mean, I'll speak to on why my plan was in place and why, I've, in process of purchasing this project and put the effort and all the energy into designing this project is SRR zone has an outright use listed for a hotel and motel. Clearly this was a zone that somebody established as a location for that use. I get your point. I understand that the development of Manzanita, how quickly things are evolving there and the areas have changed. I would note that this site is a block and a half away from Coast Cabins, which I think is a really successful project for the community. Across to the east, though it's residential, it's high density residential. There's 32 plus units per that acres of development. Very high density, probably similar to what the unit count is that I've designed. To the north, right across the block, is a series of duplexes, triplexes, quadplexes. Down the street to the west, a block away, is another hotel. And so I don't think that this project is out of character with the fabric of Manzanita. I think it's very much in character and density and I guess use of that region of Manzanita. I understand there's small cabins to the east, but if you don't look at the cabins as an individual and as a group, it's a big cluster development that is a planned unit development of a series of residential units. So I've grown up in the area and spend a lot of time working on designs, whether it's small commercial or residential projects. I put a lot of energy and effort in, and I think the code acknowledges and uses this space as a location for a hotel. And I think I've put a lot of energy and effort into minimizing the impact of its design and integrating it into the landscape and being very similar in typology and in fabric of the, I guess, the micro version of Manzanita in that corridor. So I would somewhat not disagree, but somewhat be, I guess, against the fact that this is completely out of character of that surrounding area. And I think that, as I know the whole idea of short-term rentals is an issue within Manzanita and every jurisdiction up and down the coast. I think there's a broader aspect of this that, by using the zoning for its use and putting transient stay in areas that have been allocated, it starts to pull short-term rentals out of true residential communities. Across the way, the fourplexes across the street, there's a number of those that are listed on short-term rentals. So I think the intent of the comp plan was to establish areas for this use. And I know short-term rentals have kind of blown this out of proportion across many jurisdictions. So I think there's a lot of pluses to using areas for that allocation and to help with the businesses down in the main corridor of Bonita.
And one extremely brief thing I will say, just quickly to respond to Councillor Spegman's points, is that regardless of what the mismatch may be between the current city council's vision of the city and the comp plan and the ordinances as they are currently written from a previous time, like ORS 227178 just says very clearly that approval or denial of an application shall be based upon the standards and criteria that were applicable at the time the application was first submitted. Just I want to drive that point home, that regardless of what may be needed or different or better in a week, a month, or a year, there's sort of a requirement to abide by what's in place at the time the application is submitted. Thank you.
Okay, thank you, guys. So we're going to close off questions and arguments at this point, and the council is going to go into deliberation. So the council, we're now going to deliberate and make a determination. And our options as a council are to either uphold, reverse, or modify the planning commission's decision. After deliberation, I'm going to entertain a motion and a second from the council, and we'll take a final vote, and staff will prepare the final written decision. So, guys, this is just between us now. I know
Mayor,
yeah,
Mayor, may I ask whether Savani might help us start this out by, as I understand it, the applicant has the burden of proof in this particular process. And could you describe that burden of proof a bit to us? And I'm assuming that the burden of proof is related specifically to the appeal letter that was sent to us this morning, that takes each of the planning commission's decisions one at a time, and that the applicant is responsible for providing a burden of proof to overturn those decisions of the planning commission. Am I correct?
Yes, Councilor Nettle, that's correct. So the section of the code that we're looking at or review on the record is 10.180. And the appellant, section E there says the appellant bears the burden of proof. So that means that the appellant has to show that the grounds for appeal are met. And the appellant you have to find based on the record. If you're going to agree with the applicant, you find based on the record and based on the argument submitted today that the planning commission's decision was either incorrect or should be modified in some way. If you don't find based on the record that the planning commission's decision was incorrect, or if you find that it's sort of a 50-50 call as to whether it's correct or incorrect, then that's then the planning commission's decision will stand.
So from my perspective, a couple of items that were discussed today by the applicant were technical in nature. Timing of the response, timing of the appeal, timing of the notice, timing of submittal of materials. How do we as a council respond to those kinds of things without, I guess I'm just going to say, how do we respond to those kinds of things?
So for procedural issues, I think as the applicant mentioned, if you find that there were procedural issues, for instance, it's the applicant has asked you to consider whether, for instance, the notice was insufficient. If you find that the notice was insufficient and that if you find that the notice was insufficient, and that the applicant was prejudiced by that notice, then there are options before the council based on this. Your option would be to take that into consideration in making your decision. And that may include finding for the applicant that, well, I guess that's a more complicated one because there may be other options before the council. I guess what I'm trying to say is that you will have to determine some of those procedural issues. And if you find that they substantially prejudice the applicant, then that should factor into your decision on the overall approval or denial.
And can we ask a staff during this process about the notices and those kinds of things to describe how the process folded or came about?
I think it's appropriate if the council does have questions during deliberations that are kind of clarifying questions to either ask staff or to ask the applicant if you have clarifying questions.
Okay, thank you, Savani.
Well, I've got some concerns on this project. I mean, I'm sure we're all going to get a chance to talk and hash this out, but one issue that keeps coming up is the zoning ordinance versus the comp plan. And I took a look at the person, I can't find it. The Oregon Planning Commission guide that basically says that it says both the comprehensive plan and the zoning code play important roles in land use decisions. And it further states, and I quote, "The comprehensive plan is a controlling document." This is from the Oregon Planning Commission guide. So that's obviously an issue. I hear a lot about, is this a hotel? Are these dwelling units? It doesn't look like a traditional hotel that I'm familiar with. Are they short-term rentals? Is this a situation where, I guess you could make a point they're skirting around the short-term rental laws. We got one owner and 34 dwellings. We got small cabins all over the place. Is it truly a hotel, or does it give them the ability to rent all those and go around the short-term rental regulations like our cap, and that you can only have one owner per short-term rentals? I think there's some questions with all that. I was pretty concerned to hear that the golf course was not consulted at all on this project and is not in tune with the project. And what Steve was getting at in that definition that we were talking about, it's supposed to be the comp plan. This development should supplement or support the golf course was the intent originally, and there's no tie-in here at all. It doesn't even sound like they've had any of the discussions. So as you guys all know, I started my city service on the planning commission, so I know how hard these guys worked on this project for 4 months. And they're a real long-serving commission. They're experienced and hardworking. And I'm going to say that I'm going to stand with the commission today. I agree with their findings and the way they were worded, and that's where I'm standing right now. So, anybody else wants to talk? Go ahead.
Mayor, I agree with your concern about the applicability of the comp plan. We've all been studying, obviously, for a couple of days now, maybe longer, the plan unit development section of the zoning code. It runs 3 pages. It makes 4 explicit references to the comp plan. So that made me think the comp plan must be sprinkled all over the zoning ordinance, which is 115 pages. It turns out it's really not. It's not mentioned a whole lot at all, but it's mentioned 4 times explicitly in the 3 pages of the code that we're supposed to be looking at here today. And our rules of council procedure that govern this hearing also specifically tell us to follow the comprehensive plan. And so I have heard the legal arguments to the contrary, and I do understand and appreciate them. And I recognize that, you know, there are a couple of different ways to look at this, but I don't see how we can disregard the comp plan here. And so for largely for that reason, I'm inclined to vote as you are. However, I do have a couple of concerns. I mean, one is that the green light engineering traffic report is a significant part of the Planning Commission's rationale, and it certainly has garnered a lot of support from the community. But the appellant is suggesting it's inadmissible, and so I do think we need to have a separate determination that either that's in or not. And so for that, I think we need to talk with staff to better understand the argument that's been made that the record was closed back in March, and that subsequent information such as a green light engineering report shouldn't be allowed in. That wouldn't be that's not what I hope, but I want to make sure I understand the legal argument that's being raised by the appellant.
Why don't we ask Layla and Walt if they can give us a timeline on how that came down? Does that make sense, Jerry?
Yeah, absolutely.
Can you do that, Layla, you or Walt? Just kind of give us a timeline on how that came into that report came into the process here?
Yeah, I can jump in quickly and I can look it up exactly, but staff received that as a public comment almost immediately before the commencement of the June 20th meeting.
But what do you say about the appellant's argument that the record closed in March and was only left open for a limited purpose? I think that's what I understood the argument to be.
And I can have Walt fill in on that. The record was reopened and noticed because of the additional information that the applicant was submitting to the Planning Commission. And so we re-noticed that and allowed additional public testimony because of the new evidence that was submitted.
I concur with that. We realized that there was a lot of additional information and input, and it just made sense to reopen the hearing and to allow all the comments to be part of the record. I think the other issue is that with the traffic report submitted as a comment, the applicant probably did not have enough time to respond to that. We were running very close to the 120-day limit, and we could not extend the Planning Commission meeting any further without the applicant waiving the time limit.
It's the same restraints that us as a council ran into when the applicant did not extend the time limit for us, put us under the gun to where we're at today.
I'm not going to agree or disagree with that, but you're right.
Okay. That kind of answer your questions, Jerry, on that a little bit. Well, I'm going to call on you guys one at a time. I need your thoughts here. We got to work towards a decision here. Steve, where are you at on this thing?
I guess I want to go on the record as suggesting I spent as much time as I possibly had over the weekend and even as early as very early this morning, going through all of the record, all of the testimony, re-listened to the 5+ hours of Planning Commission June meeting. And I agree essentially with both the mayor and Jerry's comments regarding the comp plan and this particular project. I'm troubled to some degree that the basis of some of the response by the applicant is technical in nature in terms of timing and things, not substantive in nature, in terms of opposing some of the things that the Planning Commission suggested. So without going into a lot of detail, I'm just going to suggest at this point, I'm supportive of upholding the Planning Commission recommended report. And I guess the applicant has already suggested they're taking objection to our notice process. So I don't know that there's a lot that I can respond to with that anyway.
Yeah, you're right. There's a lot of technical objections to timelines and this, that, and the other thing. And I don't think we're in a position to respond to that. I think we just, in my opinion, I think we just need to stay on substance here and come up with a result. So, okay, Linda.
Okay, so I've read, just as Steve and Jerry have done, I've read all the reports. I've listened and watched to the Planning Commission as they undertook very extensive and thoughtful deliberations. All of the information that was submitted by the applicant's attorney, I found interesting in nature and with some substance. I also appreciated significantly the input from the community. I don't know, in all of my time serving as a city councilor, there has been such heartfelt, well thought out, well researched on very technical issues, the issue that this is brought up. And the comments were not casual in nature. They were heartfelt and they were well researched. And I applaud the community for taking the time and interest and for sharing those throughout the process with the Planning Commission and with us. Based on the Planning Commission's extensive review and their commitment to the community, I support the decision to support the Planning Commission's decision to deny the application.
Okay, Hans.
Well, most of us have talked about this relationship between the comprehensive plan and the zoning ordinance. And there's certainly, at least on my part, and without speaking for other people, there is some conflict and confusion and perhaps omission in connecting these two vehicles. But both from watching all three of the Planning Commission meetings, some very compelling testimony, especially by Denise Loffman, which was early in the first meeting. And my own experience in being on the Planning Commission for over 4 years and being an applicant to the Planning Commission 4 times, I'm sympathetic to this applicant. We do not have a perfect ordinance, but this is the ordinance we're working with right now. And I have enough reasonable doubt that with lack of strong support from any neighbors, and in light of a unanimous Planning Commission decision, I'm reluctant to modify or reject the Planning Commission's decision.
Well, sounds like.
Mayor,
go ahead.
I just want to have a follow-up, I guess, to Linda. And I think everyone would agree with this. This was an on-the-record process. And even though I very much appreciate all of the interest by the community and the letters that we received, and there were a significant number, I don't think the council itself understood the fact that this was on the record and we weren't in a position to be able to use those letters, essentially many of them, in our deliberations. It's a result of the fact that we can only use those documents that were part of the original June 20th hearing. The other thing that I wanted to make a comment on is because it occurred to me that there was a comment made by the applicant, I think Mr. Harris, regarding that they had no access to the staff report, but I believe the staff report's been around now on the website for a number of days. I don't know specifically, but it seems to me it might have been last week that that document was available. And it's something we probably should respond to them that in fact it has been available for a number of days. So let's make that clear.
I think the public should also know that during this process, for the last 4 months, the Planning Commission has worked this issue, knowing that our body is where it goes for appeal. We have not been participating in those meetings, looking at the testimony or attending those meetings. And only in the last week or whatever have we been getting up to speed on everything that took place after we received the appeal. So I don't, it sounds like we're all pretty much in agreement here. I don't think we need to wordsmith any of these findings or change any language unless somebody feels that they need to, but I'll entertain a motion to the council to uphold the decision of the Planning Commission to deny this application.
I second.
I need a first. You want to be first? Go ahead, be first.
Okay, so I move that we deny the application process put forth in this discussion.
Yeah, we're upholding the Planning Commission's
Upholding the
denial of
plan.
the application. Can I have a second?
I'll second.
Is there any further discussion? All in favor, say aye.
Aye.
Anyone opposed, say nay. I believe that is a unanimous decision. Thank you, everybody. Anything else we need to conduct today, Layla or Savonia? Or
Just to clarify next steps, staff will be preparing the final written opinion, which will reduce the council's decision to writing to uphold the Planning Commission decision with no modifications.
and then we'll get that out before the deadline Saturday, right?
Correct.
Okay. Okay, thank you, everybody. We're adjourned.